Can you believe it? Someone got pulled over with a BAC of .287, 3.5 times the legal limit, and tried to talk their way out of jail with a sob story. Another just finished a 90-day sentence, only to violate probation days later, begging for bail to attend a mental health assessment. These two repeat offenders took self-destruction to a whole new level, but Judge DeSanto's response, pure, unapologetic justice. You won't believe how this ends. Stay tuned till the end for maximum satisfaction. Hey everyone, welcome back to Law and Humanity, your go-to channel for real, unfiltered courtroom moments. Today we're diving into two cases that prove one critical truth. Skipping court has consequences, especially if you're a repeat offender. In the U.S. legal system, failing to appear for trial isn't just a mistake, it's contempt of court. And these two defendants, they didn't just skip once, they made a habit of it. Now facing Judge DeSanto, they're scrambling to come up with excuses. Spoiler, it doesn't work.
What's your name, sir?
Judge, this is Cameron Marriott.
Oh, Mr. Marriott, you look a little bit different. Okay. All right, let's go on the record in the matter of the City of Wyandotte versus Cameron Marriott, 26377. 23122 211536. My favorite type of case. I have 15 different files. All right. And counsel, your appearance, please.
Your Honor, good morning. Richard T. Serrano, 383. Your Honor, I appear on all matters as appointed counsel on behalf of the President. My client presently is in custody. Sir, please state your name. What's your name, sir?
Cameron Marriott.
All right, Mr. Marriott. Thanks for joining us today. This seems to be the only way to get you here is in custody because you failed to appear on a number of occasions. In any event, counsel, as to the arraignment on the new case.
I advise the nature of the charges against him. He understands them.
There's no talking in court, please.
And we waive full reading stand. You ask for a plea not guilty to be entered on his behalf for arraignment purposes.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And counsel, same situation. Do you want to go over the time with your client if he wants to waive that time for the 14 days and he'd be at 16 days? Otherwise, we can put it on the first, but we have currently scheduled, as of Friday, we have 97 cases scheduled on Wednesday, the first.
I understand. Mr. Marriott, do you waive the time period and agree to appear on the 8th instead of the 1st?
Yes.
All right. We'll set this for April 8th. 11:15 a.m. Then also on the 231222, this is also an arraignment in this matter because your client had a warrant issued for his arrest. And because he failed to appear once again for this matter, we've been waiting to arraign your client since July of 2023. And so counsel asked arraignment on this matter.
Right. Once again, I've been of the charges. He waives full reading stand mute.
And your client also waives time on this one as well.
Yes. You want these combined on the same date, don't you, sir?
Yes.
Sir, are you having a hard time hearing us?
I think he said yes.
Hold on, counsel. Are you having a difficult time hearing the court through the microphone, sir? I can't hear you.
Oh.
Okay. And then the probation violation is the 211536, so we'll set this for the same day, counsel.
All right, Runner.
Yes.
231222, please, is a state mission.
Oh, it sure is.
Issue case. Your Honor, we're prepared to plead on that one today if the court pleases.
Well, no, we'll just set this for April 2nd
All right.
At 8:45.
at 8:45. And we'll set the probation violation to be on the same day as his arraignment his pre-trial on the 26377 date. So Crow issue enter a not guilty plea on that matter. All right, and counsel as to bond.
Your Honor, obviously, appearance is an issue by my client. He's failed to appear in the past. He's said he was going through a lot of things, as all people are in their lives. Somehow could not fit appearing in court on these matters into his schedule. Well, Your Honor, we asked the court to its discretion to apply a bond in reasonable respect to post. And sir, did you tell me where you're working somewhere now, sir?
Yes.
Where was it again?
Shit. The mailing plant
Sir?
warehouse.
You said you were a warehouse, wasn't it?
Yeah.
Okay, what's the name of it?
Delivery point mail service.
Okay, and how long have you been there?
About a year and a half.
Right, a full-time job?
Yeah.
You support any children, or are you married or single?
Single.
Any children? All right, Your Honor, we ask the court to consider bonding reasonable respect to post. I'm sure there will be conditions along with it.
Well, let's see here. First of all, sir, you're in court, so please make sure you're paying attention to your language. And are you still with Miss Pepke? I think at one point you and Miss Pepke were in a relationship. Is that still a thing?
No.
Okay. I think she's failed to appear before, so I just wasn't sure what that was. But the court will note on your 2021 case, sir, you have a significant history of failing to appear, and you're on probation for operating while visibly impaired. And now you have a charge of public intoxication. So, and the court will note that you did post a bond October 1st of 2025. And then you weren't scheduled until March of 2026. So I don't know what happened there, but. Then this court orders a bond to be forfeited, but now you've been within your 28 days. So I presume that the court's going to reinstate the bond or continue the bond in that matter. Are you out on bond in any other jurisdiction, sir?
None.
And if you were to test today, sir, what's in your system?
Alcohol.
Anything else?
No.
How do you get back and forth to work, sir?
I take the bus.
So you're telling this court you've never failed, have you failed to appear in any other court, sir?
Yes.
What other courts?
Plymouth.
And do you have warrants pending?
Yes.
Okay. And so here's what the court's going to do. So first, your client's on probation in this court for operating while visibly impaired. And it's fortunate, apparently, that the police came across your client before a motorist that didn't see your client, so that he didn't get hit while he was stumbling across the Fort Street. Because it's alleged your client had a .287 alcohol level. So here's what the court's going to do. On the 26377 matter, given your previous failures to appear in this court and other courts, the court's going to order a $7,500 10% bond. You are not to possess or consume any alcohol or drugs unless prescribed. You are not to be released via GPS and alcohol tether all through the Wayne County Jail. That's on 26377. The court's already reinstated continued bond on 211536. And on 231222, the court's going to order a $5,000 10% bond with the same bond conditions. Good luck to you, sir.
Your Honor.
Is that all of them?
Judge, I get the next one.
There's another one. Okay. All right, then. All right. City of Wyandotte versus Leonard Roylett. 26375. And then we have 25883. And 25751.
Good afternoon, Your Honor. Neil DeBlois here on behalf of Leonard Roylett. Mr. Roylett, could you please state your name, sir?
Yes, Leonard Allen Riley, Your Honor.
All right. Good morning, sir. You know, you wanted to visit the court, you could have just walked on in and we could have said hello to you, sir. But you seem to not want to appear on your scheduled court dates. In any event, counsel, as to the arraignment on all of these matters.
Yes, my client waived formal reading and stands mute.
All right, the court will waive the formal reading on all charges. Enter pleas of not guilty on all charges.
Your Honor. Get a minute.
Yes, sir.
Can you hear me?
Yes, I can.
Your Honor, I just did 90 days in jail, got out 11 days ago. Tomorrow, of all things, I have my full assessment with team wellness all set up with the psychiatrist, with the therapist and the nurse at 12 a.m. In the past, I always just show up. If I can get to this stuff, it can give me a roadmap. And also, I was with the Judge Oakley, and he was going to talk to you again about mental health court. He thought it was important. I know it's important right now, and I got some things in my path that could help stabilize me. If you give me a chance, even if those daily reports, I can at least make this appointment tomorrow. It was hard to get my insurance activated. To get back to this, I've been in jail here 3 or 4 days. I just got out 11 days ago from 90 days. And I just, and when I was with Romulus, they did call and you guys didn't come get me right then. So it's done. Not that I didn't.
Hold on. It isn't you guys. No, stop. It isn't you guys. It's the Wyandotte Police Department. The court does not have its own police department.
I understand.
So hold on. No. I'm going to have you pause.
Okay.
Counsel, as to the arraignment.
Yes, as I said, Your Honor, my client waives formal reading and stands mute to all of the charges.
The court's going to waive the formal reading, enter plea of not guilty on all these charges, schedule these matters for pretrial. So, counsel, I don't know if you were in here when I told Mr. Serrano, but April 1st, we have 97 cases currently on the docket. So I'm not sure, counsel, if you want to waive time for your client and instead of within 14 days, it would be 16 days and put it on the 8th, or if you want to do it within the 14 days.
Your Honor, I understand that. Objection my client would have is that whether or not he's going to get a personal bond here. Okay. You can understand he's very adamant about getting to this team wellness appointment.
All right. Well, then we will set the pretrial for April 1st on all these matters.
11:15.
11:15 a.m. And I'm changing his address on all of these. The Porter Street is his new address, correct?
That's what I understand, Your Honor, yes.
When did you move there, Mr. Riley?
When I just got out of jail on the 11th of March. After 90 days.
Well, one would think then that you'd want to not get in trouble again, Mr. Riley. Since you want to be out and you want to, since you want to be out and make your appointment
I made it. I made the appointment.
Since you want to be able to attend your appointment.
I understand. I promise I will not miss court.
Sir, you know, listen.
I used to have a good record with you.
Excuse me, please pause. You
Sure.
have 3 pending charges from May of 25 that you failed to appear on. That's possession of controlled substance, possession of drug paraphernalia, fraudulent schemes and disguises. Then you have another matter from June of 25 that you failed to appear on, possession of drug paraphernalia. Then you were arrested, appears on Friday, for possession of drug paraphernalia. And sir, what did you serve 90 days for?
I served 90 days for retail fraud, Your Honor.
Right. Which is what is littered all throughout your criminal history. And what were you was that in front of Judge Oakley or somebody else?
That was in front of Judge Mullins. Judge Mullins and I just served all the time and got out the 11th.
Okay, so then what were you in front of Judge Oakley for?
I had previous stuff with Judge Oakley, but I was locked up on a subsequent matter that I couldn't make court, but then he's seen all that. And so he gave me a personal bond out of Romulus. Romulus did try to contact Wyandotte to come get me. Wyandotte didn't want to come get me right then. That's the truth, on the 11th of March. And then I got my court date the 26th on Zoom with Judge Oakley. He was going to get a hold of you to try to do something with mental health. Like I said, I made my appointment, but I got March 26th Zoom with Judge Oakley and Romulus. And I have my 12 o'clock appointment tomorrow with Team Wellness.
Well, Mr. Rowlett,
I just did 90 days.
you're probably going to have to reschedule that because, you know, we, and I don't know that you would be eligible to participate in our treatment court again since you were removed, for lack of following, program, protocol.
Was with you a long time, Judge.
I know that. I know
I
that.
have my.
And we tried
my
helping
stuff
you for a
tomorrow.
very long time.
I got my new mental health tomorrow that can go a long way. And I got that on my own. No one told me to go there. I knew I needed it. You know?
Well, you still have warrants. Let's see, from March of 25 in Taylor for, it doesn't say what for. You failed to appear for pre-trial, but hold on, please don't interrupt the record. Then,
I'm sorry.
a couple out of here. So you
Right.
still have a warrant in Taylor to take care of.
Oh.
So, given Mr. Rylette's continued failure to appear in court, the significant criminal history and the charges, you have 3 of the same charges in all 3 cases. That's possession of drug paraphernalia. If you're to test right now, what's in your system?
Nothing, Your Honor. I've been in your jail 3 or 4 days now. If